Thank you.
Thank you, Dipti. I think this LODR topic that you are doing this masterclass is very relevant. There are so many changes, and the regulation is still getting settled. There are clarity required in some of the provisions. There are some provisions where industry practice has to evolve. So I think this is very right time to have this kind of deliberation to get more clarity and have understanding on these topics. And the current topic that had been selected, Regulation 2627 particularly, although it is very small piece of the LODR, but there are very important provisions. And the recent amendment, particularly with respect to whether it is disclosure on cyber security or within 3 months replacement or succession planning, those things becomes very, very important. So I think those we will deliberate. But yeah, whole industry is buzz about all these provisions. Thank you.
Thank you. Sudhakar, please.
Yeah. Thanks very much, Dipti, and good morning, everyone. Today we are entering into the fifth part of our past class on SEBI listing regulations. As we discussed in the last webinar, that Regulation 24A, which talks about secretarial audit as well as secretarial compliance certificate. In fact, we discussed these two in depth, and at that point of time also we said that when the company secretary in practice have to give the secretarial compliance certificate, the objective of this is that SEBI wants to ensure that somebody has to have a check on each and every compliance of each and every regulation. And company secretary in practices have no what's called as a scope even to cover any kind of non-compliance, because this is just like an objective type questions. So understanding of each and every regulation of the listing regulations for the compliance officers is imperative. And as Randhir has rightly mentioned that in the recent past, for the last 6 to 9 months, a lot of changes have come in the SEBI listing regulations. And whenever there is a change in the or any kind of amendment to the listing regulations, this is leaving a lot of scope for interpretation as well as deliberations. In fact, that is one of the primary reason why we thought that let us take up a master class and let us also discuss in depth of the regulations. Unlike the seminars and conferences where we take about a couple of hours for the entire listing regulations, we thought that let us pick up 2-3 regulations and then discuss it at threadbare. So today we are on 26 and 27. Though it looks like it is a very small, the topic as such, but the objective, as I have mentioned, is let us take a deep dive into these regulations and understand the nuances of that. There is no point of what's called taking a big slice and not able to chew that. Instead of that, why can't we have small pieces, chew it, digest it properly? That's the objective of this. So I'll give a pause here, and maybe Bala can take it up further.
Thank you, Sudhakar. I forget to introduce Ms. Neerja, who is going to present here. She is a qualified CS with 4-5 years experience in India. And of course, one important thing, wish you all happy and prosperous New Year. And this is our first session. After this, our Vikram Savat New Year. And let's hope we more worship Goddess Saraswati, and we are able to serve and satisfy the knowledge requirement and thirst of more and more people. Thank you, everyone. Yeah, over to Bal.
So pray Goddess Saraswati and Lakshmi will come automatically.
Yeah. Yeah, Mr. Bala.
Good morning to all of you. I have a great pleasure in meeting you again and again, week after week. Because always the life, life is teaching us lesson every day. And our duty to learn whatever the teachings are coming on ongoing basis, because there is no ever ending to the learning. If we look at the LODR regulations, ever since the class 49 has been introduced and subsequently changes taken place, that the LODR has come, and after that Companies Act 2013 has come, where the Companies Act recognized company secretary and the chief financial officer, the KMPs, and also brought the consult of senior management. Now the entire LODR regulation has brought the senior management under the ambit of the LODR regulations. Because that is a big change which was taken by the LODR regulations by the SEBI. Entire senior management has been brought under the ambit of the LODR regulation in par with the Companies Act recognizing the things. That is why when Randhir was talking about the 3-month filling of the vacancies, etc., which comes to, it is not only applicable for the director, but it's also applicable for the senior management. So in which case, although the regulation 26-27 being a small topic, but when we go to the nitty-gritties of filling up the vacancies, getting a thing, finding the suitable people, etc., whether that sufficient time is enough, that is one question. But at the same time, regulators also actually put in a place what we call the succession planning. That means the organization should be ready to have the second line person. If you ask any organization today, this gentleman is actually your CEO. Who's the next CEO? They should be able to answer who's to be the next CEO. That is the readiness the regulators are actually looking forward to. So really speaking, we will have the practical experience from Sir Randhir because he is coming from the Dr. Reddy's, a larger organization. What are the nitty-gritties, how they do it, and all these things will be glad to share with us. That is one thing. And second thing is, again, when we are talking about the affirmation of the code of conduct and business ethics, although the regulation started with saying, the senior management has to affirm, it is not only restricted to the senior management, it is actually across the company, everybody. It is not ethics to be followed only by the top management, not for the lower management. It is across the company, everybody has to follow. When we talk about the affirmation has to come for the entire organization as such. So how do we actually get implemented? What are the things? How the awareness is actually created? What are the training is done? How the people come to know right from the day they join? What is the culture? What is the ethic? What is the code, etc. and other thing and all. There also, I think we'll have a practical experience from Mr. Randhir, how it is being implemented, etc. and other things and all that. In many of the organizations, when they are doing what we call the KPA and KRA, that means, key performance indicator and also key performance appraisal, they make it as a part of the culture itself, what we call the behavioral code, the code of business ethics, the code of your behavior, code of your value, etc. and other things and all. Because that is one of the factors which is actually determined many organizations. It is there actually, the organization where I was also working, it was actually part of it. So there are many nitty-gritties are actually involved. Although we are talking the regulations very small, it looks like, but it is not so. When you look into the practical implications, how do we go about it? How do we implement it? What are the problem across? That is what is the deliberation is going to be there. Dipti, you are talking about the Deepavali mood. It is already 100. You can see that people want to skip the introductory part of it. They want to join. So that seems to be the things, nothing else. So I think, anyway, we are like that. There are two issues, Dipti. One is, if I am late, I am better. I don't want to be punctual. That is one. Second thing, it will listen the introductory part of it. That's the second thing. Anyway, that's a part of it. It's all right. But the one thing is that today I really definitely expect a lot of things, learning will happen. Many practical aspects will be known. The participants are requested to put their queries as usual in the chat box. We'll take it up then and there. And if anybody wants to talk, they can raise their hand. They can also share their experience. The whole idea of this session is sharing of the knowledge between each one of us. That is the thing. With this word, I give a pause here. I'll ask Neerja to take the presentation. Over to Neerja.
Yeah, Neerja, start.
Yeah, just Neerja, 1 minute before you go further, let me also make one small announcement that several people are making requests that we should take up a series on takeover regulations, buyback regulations, as well as stock options like that. We can assure you that in the coming days, definitely we are going to do that. This kind of feedback, what you are giving to us, and that is quite encouraging. And certainly we are going to take up these these three aspects also in the coming days. And yeah, go ahead, Ned.
Okay, thank you so much, sir. Good morning, everyone. Good morning, panelists. Thank you for giving the brief introduction about the topic. So now I'll share my screen and we'll start the presentation. Today, the topic of our webinar is obligation with respect to promoters, directors, KMP, and senior management. Starting with Regulation 26, Sub-Regulation 1 of SEBI LODR regulation states that it imposes restrictions on the membership and chairmanship of the listed entity's director. The directors of the listed entity shall not be a member in more than 10 committees and shall not hold chairmanship of more than 5 committees. While determining the limit, it is crucial to consider what are the inclusions and what are the exclusions in calculating. In computing the limit for membership and chairmanship, only public limited companies, regardless of their status, whether they are listed or not, they are to be included. And all private limited companies, foreign companies, high value debt listed entities, and Section 8 companies shall be excluded. In SEBI LODR, private limited companies, foreign companies, and Section 8 companies is not defined. So we will consider as the definition what is defined in the Companies Act 2013. However, Regulation 15 of SEBI LODR defines high value debt listed entities. It means which has listed its non-convertible debt securities and they have an outstanding value of rupees 500 crore and above. They are considered as high value debt listed entities. So while calculating the limit, we have to only consider the public limited companies and the other companies like Section 8 companies, foreign companies, private companies, high value debt listed entities are to be excluded. Further, for the purpose of determination of limit, only 2 committees will be considered. First is audit committee and the second one is stakeholder relationship committee, and no other committee will be included in this. Regulation 26 Sub-Regulation 2 of SEBI LODR states that every director shall intimate to the listed entity about his chairmanship and membership in other committees as well. And they should also promptly intimate if there is any change in their membership or chairmanship. Change can be like cessation of membership or cessation from chairmanship, or they have been appointed to a new committee as a member or chairman. So they should promptly intimate it to the listed entity. Here, the onus is also on the company secretary to educate the directors about the restriction that is being imposed by SEBI LODR on their chairmanship and membership also. The company secretary can do one more thing, that they can priorly intimate the directors that their limit is about to be crossed so that there will be no non-compliance. So here the onus is also on the company secretary and on the director as well. Moving to the
Neerja,
other... Yes.
before we move to next, I think this committee, number of committees which SEBI LODR has provided is already on very higher side. Considering the responsibilities that is there now on the committees, the recent amendment of LODR, or anyway, the obligation that the independent director carry. So board, over boardship as well as number of committees where the directors are member or chair, and the responsibility that they carry, whether they are able to spend sufficient time on the topic, that's a very pertinent discussion. In fact, I had the opportunity to attend a meeting recently where all the regulator of Asia were deliberating. And a Singapore regulator were particularly proposing 3 committees or 3 companies where the director is something that should be proposed. Although what is right number for directorship, how much engaged director is, it's all personal choice, because whatever number you give, whether today 10 or 5 committees or 7 companies, right? Maybe I may not be able to justify, whereas maybe Sudhakar being very active and maybe at that point of life where he can spend that time on those topics, right? So those things also matter. But yeah, this is being discussed, and I think very soon regulators are going to review this provision under LODR. And considering, if we take just example of audit committee, there are so many responsibilities of the committee. Committee meets 4 times in a year, right? If you see related party, which is a continuous, I would say, transactions which is happening, reviewing on a quarterly basis. Similarly, there are audit, there are accounts, there are regulatory, there are ombudsperson complaints, right? With NAFRA coming up on fraud reporting, the kind of expectation regulators have, the kind of responsibility these committees are carrying 4 times in a year and sufficient time, it requires that some of the committee members are responsible for some of these topics, and they are spending a whole lot of time. And these kind of numbers is not going to justify it. Additionally, maybe in the regulation, there is big numbers provided. But if you see the proxy advisory firm and other investors, they also have their own governance standard. And if we see them, they have more harsh provision on this. So particularly like MSCI considers 4 only as if a board member is more than a member of board in more than 4 companies, they would tend to recommend negative governance score on that, right? Similarly, ISS has a limit of 5. So those things are going to maybe build in the regulation when we move to next 2-3 years, and this is something that is under discussion. So limit is on higher side, and most of the companies are looking at it.
Right, Randhir, just to add further what you said, you have touched the sensitive nerve. In fact, in one of the recent forums where SEBI representatives were there, I have suggested that even the number of 7 listed companies for independent directors is on the higher side. I suggested that to be reduced at least to 3 to 4, not beyond that, because of the kind of arduous responsibilities what have been entrusted upon the independent directors in particular. At the same point of time, if you see that, as you rightly said, 10 committee memberships, okay, and though it is audit committee and SRC committee only are to be taken into account. Say, for example, if every independent director or any other director, let us admit one thing, that they definitely want to be as many committees as possible, with all due regards to them, because of that, number one, it is a kind of a prominence they will get it in the company. At the same point of time, they will get some amount of good sitting fee also. Suppose if I am on the 10 audit committees and 10 risk management committees, just see the volume of work which is going to be there in these 2 committees. And risk management committee, you are not counting. And I am there on 10 audit committees. Definitely, I am going to be a very powerful person. But do I have that kind of time at my disposal? That is to be seen. So, according to me, again, the same thing, this 10 committee memberships are to be reduced to 5, and the 5 chairmanships are to be reduced to 2 or 3 at the most. That's what the suggestion I have given, and rightly so, you have touched upon the same thing here in this forum also. Let's hope that some kind of this thing will prevail, because RMC is also to be counted, according to me, that is not to be left out as such.
Yeah,
So,
I think not only RMC, Sudhakar, you have
even NRC also.
NRC as well as
NRC
now
also to be
committees that
taken.
you are having.
Yeah.
People are having ESG committee. ESG is a new
Correct.
area, and it requires a lot of learning, skill upgrade, right? Because it touches a lot of areas. It is E, S, and G, which encompasses each and every area of the organization. And considering BRSR, considering integrated reporting, which is responsibility of board and committee, global companies are leveraging advisory role where committee is being advised by expert in that area. But despite whatever you have at your disposal, when you are responsible as a committee, as director, probably you need to spend time. So I think SEBI should review these committees which is covered, and all committees should be part of it. Because once you are part of a committee, you are responsible for a scope of work which is given to committee, and that requires some wholesome time to be given, and you need to spend that time to justify the role.
Bro, well said, Randhir.
Regulation 26, Sub-Regulation 3 of SEBI LODR states that the Board of Director and senior management personnel shall affirm compliances with the Code of Conduct. Every listed entity have its own Code of Conduct, so the responsibility is also on the Director, senior management and the company secretary also to ensure that they have complied with the Code of Conduct that has been framed. And this compliance should be reviewed on an annual basis. This can be reviewed in the board meeting or in any committee that is framed by the board. Regulation 26, Sub-Regulation 5 of SEBI LODR regulation states that the senior management shall make disclosure to the board of directors relating to all material, financial, and commercial transactions where they have personal interest and that may have a potential conflict with the interest of the listed entity. The phrase conflict of interest is explained and it relates to dealing in the shares of the listed entity, commercial dealing with the bodies which have the shareholding of the management and their relatives.
There are two people who have raised their hand. One is, I think, Pramod Shah, other is, I think, Sudeep Chatterjee. Can we hear from them?
We can take Mr. Sudeep Chatterjee, please. Mr. Sudeep Chatterjee, you can unmute yourself.
Yeah, the question is that nowadays what is happening is the SEBI regulations, company secretary become a clerk of a company due to filing of XBRL. Whatever be the information you are giving to stock exchange, they are asking PDF as well as XBRL. So how the quality times a company secretary can place for the company's purpose, because XBRL is taking too much of time. And what is the requirement for filing the same information in BSE and NSE? Why not the SEBI, who is talking so much on the corporate governance and all these things, can make a single server where we can place all this information data, and from there the stock exchange should take this for their respective heads. So that is the one very vital question that SEBI should think of. The company secretary is not a clerk, first of all. Everything cannot be pushed to XBRL. We are paying the listing fees. Let the BSE, NSE personnel should work on that after getting the information. And why this duplication of this information submission to both the stock exchange at the same time? Let make a common server where a company can place the information and the BSE and NSE can take this information from them, or SEBI can make a mandate that who is the designated stock exchange for the company, they should file the information first to that, and other stock exchange can take the information from that server.
Mr. Sudeep, we got your point. Panelist, if you want to answer. Mr. Sudeep, yes, we understood. Thank you. Thanks for your concern.
Yeah, I think that.
Randhir, would you like to take it that question first, and then I will add it further?
Right. I think this is very right concern, and as company secretaries, as industry body, this has been flagged to SEBI. I think the collaboration which NSE, BSE has today between them versus what it used to be many years back is very, very different. So I think we are moving in that direction, and I'm hopeful that soon we will have a mechanism where you have Edgar kind of filing in US, where you file in one portal and that suffice and get disseminated to all the relevant exchanges. Yeah, Sudhakar.
Yeah. So there are three issues raised here. Number one, company secretary is not a clerk. Let us not be that harsh as far as towards SEBI. But let us know one thing very well, that the SEBI, through the listing regulations, has recognized the company secretary as the compliance officer. So whatever the information to be disseminated to the stakeholders, that is to be done by the compliance officer, who is the company secretary. Number two, now why to file PDF as well as XBRL simultaneously? Why in two formats? Because several times it happens that XBRL, once they introduce that, by the time it settles down, SEBI always advises that you can file both PDF as well as XBRL. That is the primary reason. And once the XBRL thing is settled down, they may discontinue with the PDF. The third thing is, as far as NSE and BSE is concerned, I do appreciate what the suggestion is. In fact, this is there for the last 7 to 8 years. At several forums, this issue has been taken up, that why NSE and BSE should not have a common portal wherein we upload the information and let the stock exchanges, use that or utilize that. That time, SEBI representatives were also there. They also agreed that, but they have certain internal issues which they need to resolve. Fortunately or unfortunately, that is not happening. Maybe we may take up at the right opportunity and right forum, because Randhir, you are on the other committees of the Chambers of Commerce. You may also take up that. Wherever possible, we also will do that. And let's hope that these two stock exchanges come to a common platform or a portal like that. But let us not go with that what's called as mindset that we are the clerical people. Company secretary is no more a clerk. That we have discussed it at several forums. Company secretary is the compliance officer and having a responsibility of dissemination of the information to the stakeholders. Some kind of pain may be there in this process, which we have to withstand. That's what my view is. Thank you.
I echo what Sudhakar said, and I would say one more thing, that if we wear the hat of regulator, consider the PDF that is being filed and is not subject to AI or other things which is available to guide you on what kind of disclosure is, whether the disclosure is appropriate, right, wrong, right. So I think this XBRL is a right move. When it gets settled, it will help everyone. At the same time, it challenges more to us as company, as company secretary, who are responsible for this filing, that the filing standard is more better. It is accurate, because with XBRL, the AI can give even the smallest error, and that may lead to more notices in case there are wrong filings.
There is one suggestion has actually come, and there is only view is expressed. The suggestion is actually, why don't you arrange a session for the Digital Data Protection Act of 2023? I think definitely we will look into that. We will organize in days to come. And Mr. Japunathan is sharing his view, recognizing the importance of the role of the SEBI has been strengthening the regulatory regime to ensure the right appointee or appointed in the senior management. But while doing so, it may also have made a process very cumbersome, as it may not be that easy to have the meeting of a NRC or board of directors and appointments of such a key position too quick a time. Right, in my case, comply is the only option which is actually available. And I think it will benefit to the organization overall. That is what my view. That's what he is saying. But I think when we discuss this also, since the succession plan has to be in place, I think to that extent, the people should have the preparedness to fill up the vacancies, because when the resignation take place, they cannot start acting it. When the resignation happens, when they start acting it, yes, what you are saying is their time, etc., essence, everything is going to be the matter. But already the succession planning, then people have to be well prepared for any event. That is what we call, what you call disasters plan. So alternatives should be worked out, in my opinion. I think we can check with Randhir what is happening in his organization on this and the practical aspect. Over to Randhir, please.
Sorry, repeat the question.
Question is, senior management positions.
Yeah.
Too quickly filling up the vacancies and appointment, calling the NRC meeting and board meeting.
Right.
It is not always possible. So it becomes very cumbersome. That is what he says. But anyway, complaints the complaint. We'll have to comply with it. That is what he says.
Right.
So
right.
I said, since I said succession plan is required to be in place, I think we should be in preparedness rather than, starting from the beginning after the events take place. That is what I asked you, your views. Yeah.
No, you are very right, Bala. I would say that the world in which we are living is so vulnerable that it cannot be left to the point of time when someone is moving out. There has to be a very robust process around succession planning, not only for the top management, but also, I would say, key people. So key talent which is there in the organization. For them, succession planning, a very robust succession planning is required to be in place. And considering this regulation and the other consultation which SEBI was doing, like CEO being responsible for so many things and accountable in case CEO is in case the default continues, then even the freezing of demat account of CEO was being discussed, right? So all these things are in a direction that key people who are in the organization, which includes KMP, senior management, at least, they are accountable. They are there in the position. They are not there like 1 year, you don't have a person. So when something happens, SEBI is looking or regulator is looking for someone to be accountable, and no one is there. So this is right that there should be a time limit within which the position is filled. Companies should be responsible to look at the ways, the processes in place, and identify the person. And if you don't have the right person, probably you do the interim measure. But yes, it should be in line with the required compliances. For example, if you are hiring CEO or CFO or company secretary, they should have the requisite qualification and accountability and responsibility. And tomorrow, if such incident happens, SEBI has someone who could be held accountable.
I think you're right. And as we have to accept that an organization only not managing director is the only person where immediately you require a technical person. As and when any chief of the organization resigns, immediately they declare in a week or kind who will take care. Now it is recognized not only top position, but each important department. This KMP is KMP. It is recognized important position. So why it should be also left? It's, administrative process take time. So that's why, as rightly you mentioned, interim measures has to be done. Take your time. But that person is made responsible, because who will be responsible in that gap and who will take decision? So I think they are giving importance, and as an organization as a whole, you are required to fill up all important position, not one important position. Which is
I have seen very robust processes. I would say, as a ecosystem in our country, the HR processes are very, very evolved. The company's HR organization, CHRO, top management, CEO who is dealing with the NRC on an annual basis and quarterly basis have a lot of good processes, not only to see who is going to take the position 3 years, 2 years, 1 year, 5 years from now, but also in case the person is not there, then what the companies are doing. In fact, NRC is interested in meeting the second and third line people, and they are spending time with them to understand whether what is being presented is right, whether it is aligned. They are also getting a feel of the person who is going to take that position after 3 years. So I think there is very robust process, and where there is a gap, the companies need to create those processes and work around that. Otherwise, the regulation will create challenges.
Yeah. I think if everyone given the view, we can go ahead with the presentation or any practice. Yeah,
we'll go ahead.
Yeah, please. Yeah, Neerja.
Regulation 26, Sub-Regulation 6 of SEBI LODR requires prior approval of the Board of Directors as well as of shareholders by way of ordinary resolution if any employee or KMP or director or promoter of a listed entity enters into any agreement for himself or herself or on behalf of any other person with any shareholder or any other third party with regard to compensation or profit sharing in connection with the dealing in the securities of the listed entity. Further, the interested person who is involved in the transaction is not allowed to vote in the general meeting where such transactions are put forth before the shareholders for the approval.
I think when this provision was introduced by SEBI, maybe it was limited in the scope in terms of how the people are using it and what opportunities is there. But now I'm seeing that this portfolio management services, PMS, which is very, very easily available, right? Even for investment like 30, 50 lakhs rupees. And there, if you have substantive number of shares through ESOP that you have, say you have shares of the company of 50 lakhs or 1 crore, PMS is proposing that you give me these shares and I will trade on your behalf with this money by placing or using this as security amount. And probably these are the additional challenges which is there. And as company secretary, as an organization, awareness has to be created that this provision may get triggered, and to watch for these kind of situations and guide the people in the organization correctly.
Yeah. Yeah, Neerja.
Interested person is defined in the regulation. It means any person holding voting rights in the listed entity and who is in any manner, directly or indirectly, is interested in an agreement or proposed agreement entered into or to be entered into by such a person, any employee, KMP, director, or promoter of such listed entity, with any shareholder or any third party with respect to compensation or profit sharing in connection with the securities of such listed entity. Now, moving towards the recently introduced, which is this regulation, Regulation 26A, is being effective from 15th July 2023. It provides for the filling up of vacancy in the office of Chief Executive Officer, Managing Director, Whole-Time Director, Manager, and Chief Financial Officer. If there is any vacancy, it shall be filled by the listed entity at the earliest, and in any case, not later than 3 months from the date of such vacancy. Further, proviso is also provided in this regulation. It specifies that the vacancy of appointing such a person should not be filled in an interim capacity. It can be filled in an interim capacity if it is there in any other law that is applicable to the company. Further, I would also like to specify here that the vacancy of a company secretary is not specified in this regulation because a separate regulation is being dedicated for that. That is Regulation 6 of SEBI LODR. And the vacancy of a company secretary shall also be filled by the listed entity at the earliest, and in any case, not later than 3 months from the date of such vacancy.
Only thing, Neerja, though we were discussing this issue yesterday, in fact, again, I have gone through Regulation 6. What Regulation 6 talks about is the compliance officer should be a qualified company secretary for the purpose of listing regulations. So technically, the company secretary of the company need not be the compliance officer, though most of the cases it so happens. But suppose, say, for example, if I am a company secretary of a company, I can choose that somebody, my colleague who is a qualified company secretary may be the compliance officer. So in such case, that Regulation 6 talks about the compliance officer, but not the company secretary who is the KMP of the company. So to some extent, there is an ambiguity. One can take a shade that, okay, look, in fact, under 26A, company secretary as such is not getting covered within 3 months. That's what my view, and it may be a slip up or something like that, because SEBI also might have thought that Regulation 6 is there. It will be taken care of. In fact, in one of the WhatsApp groups, I remember earlier the same question has cropped up, but much discussion was not there. What do you say, Randhir, about this?
I'm aligned with what you are saying, Sudhakar. It is a compliance officer, and compliance officer not necessarily would be company secretary. There has been many situation where CFO has been appointed as compliance officer. There has been separate compliance officer in many companies, even for
In fact, State Bank of India is there. State Bank of India, the company secretary of State Bank of India is not the compliance officer. The compliance officer is someone else. In fact, keeping that in mind, only yesterday night I was going through the Regulation 6 once again. So my view is that this particular neither 26A nor Regulation 6 is taking care of the appointment of company secretary. But of course, under the Companies Act, within 6 months anyway, you have to appoint that. Anyway, companies should not take advantage of these kind of ambiguities, whatever are there. But certainly, in case of any situation comes, God forbids, this may be a kind of one can take excuse from this like this. Yes, Neerja.
Regulation 27 is about the compliance governance report. here regulation 27 sub-regulation 1 states that the listed entity may at its discretion comply with Part E of Schedule 2. Part E of Schedule 2 of SEBI LODR states that a non-executive chairperson may maintain a chairperson's office of the listed at the listed entity's expense, and he will also be allowed reimbursement of expenses incurred in the performance of his or her duties. A half-yearly declaration of financial performance, including summary of the significance even in the last 6 months, may be sent to each household of shareholders. These all provisions, these are all discretionary, they are not mandatory. It depends, it is totally on the listed entity to comply with them. The listed entity may move towards a regime of financial statements with unmodified audit opinion. The listed entity may appoint separate persons to the post of chairperson, managing director, or CEO, subject to the condition that the chairperson should be a non-executive director and he should not be related to the managing director or chief executive officer, and the term related should be defined from the term relative. He should not be relative of the managing director or chief executive officer. The internal auditor may report directly to the audit committee. Further, this was the discretionary portion where the listed entity may comply with them. Now moving towards the regulation 27, sub-regulation 2, clause A of SEBI LODR, it states that the compliance report on corporate governance has to be submitted to the stock exchange within 21 days from the end of each quarter. This report has to be submitted in XML format. A XBRL utility is downloaded from the BSc and the NSC portal. They are filled up and then an XML file is generated and it is being submitted in XML format. This has been made mandatory for both the stock exchange. If the company is listed on BSc and NSC as well, then the listed entity has to submit to both the stock exchange. And if the company is listed only on BSc or only on NSC, then to the respective stock exchange, we have to submit this report. Further, regulation 27, sub-regulation 2 and clause B and BA states the disclosures to be made in the corporate governance report. All the material transactions with the related parties are to be disclosed in the report, and recently introduced, that is with effect from 15th July only, cyber security incidents or breaches or loss of data or documents are there. So these events are also to be disclosed in our corporate governance report.
Yeah, just 1 minute. Go back, Neerja. So,
Yes, sir.
Randhir, that you were talking about the cyber security related what's called
Yeah.
nuances, and why can't you deliberate on that, please?
Yeah, I think on this, the provision is a welcome provision, but the issue is only that it is not clarifying that what kind of cyber incident has to be reported. The way the language is currently, it requires each and everything to be reported. And when I compare it with the other geographies like SEC in US has also similar requirement where cyber incident has to be reported diligently to the SEC. The only difference is that they have used the word material. So only material cyber incident has to be reported versus SEBI LODR requirement where it is left on the company probably, or if you go in a strict interpretation, each and every incident has to be reported. And you all agree that the world in which we are living today, every day company has several small such incident where some hacker is trying to hack, but you have a very strong process system which is not allowing it. Whether that incident has to be reported, whether it is benefiting anyone, whether it will help investors. So, and are we overloading information on exchange or with regulator? So some clarity is required. And if I go back last year when the consultation paper had come on this from SEBI, I think there were a lot of additional requirement beside this, that the date of the incident and what kind of incident happened, and brief detail. These 3 requirements are there in current LODR versus the consultation paper where they were asking for nature of event, date of event, brief of the event, and then corrective measures, what corrective measures has been taken. and then impact on operation and compliances in terms of CERT. These were the additional requirements that SEBI had proposed. We represented, and I think industry representation helped to make it refined to 3 requirements. But yes, materiality is something that needs to be added or clarified, that only material incident, or in case there is other view of SEBI, then maybe definition of cyber incident which needs to be reported will be helpful.
Since you started only the last quarter, probably you also would have submitted the report.
Yeah.
So in your case, could you share what is done? Is everything, or it is materiality? Or
Yeah,
do you
so-
also have an idea about the other industries, people, how they are thinking?
Yeah, so I think definition of cyber incident is given in Information Technology Act, which is very, very wide, which is, you see, general regulations have that kind of definition. And then if you see what is reportable to CERT in, which is like similar to CERT US, there are almost 20 kind of incident which needs to be reported to CERT in case such incidents happens. In companies, this is a complex technical area. I was having discussion with my chief security officer, and I was trying to understand that what would be best to report and how we could have a process of reporting on this. So anyway, because SEC has a requirement, so we have a very robust process to report to Risk Management Committee on a quarterly basis. And monthly basis also internally we review such things at senior management level. What to report was the question. So there are 3 different categories in which incidents are divided, and what qualify action by the security team is something we thought should be reported, and that call we have taken. But yeah, we are looking forward to more clarity on this from SEBI, and this is as of now not in public domain. When you file this particular piece with exchanges, it is not viewable. So I hope that regulator will see the reporting by different companies and come back with more clarity on this.
Just to
Mr.
add
Sudhakar,
further,
your use?
Yeah. Sorry,
Yes, Sudhakar.
Bala, go ahead.
No, your use. I was seeking your use.
Yeah, okay. See, only thing what I was trying to say here is that cyber security incidents or breaches or loss of data, this definitely also trigger Regulation 30. Okay, though I to my best of my knowledge, I don't remember it is not coming under para A, but definitely it will fall under para B. So whenever any kind that of course depends upon materiality. So what we have to do is whatever you are intimating to the stock exchanges under Regulation 30 with respect to cyber security related issues, that it is imperative for the company to also report under 27(2)(b). Over and above that, we need to do anything? I don't think, okay, because see, again, yesterday as we were discussing, say, for example, in Regulation 30 under para A, any kind of imposition of penalties and fines are to be intimated under para A, which is mandatory. And they have not used the word material there also. That means what, even 1,000 rupees penalty, if they are imposed on me, I need to inform to the stock exchanges. So that becomes a mockery then. Okay, every company, they will dump the stock exchanges with the kind of, because the big companies, conglomerates and all, okay, there will be several incidents, thousands of incidents may be there on daily basis rather. So that might not be the objective of SEBI. So one can always, whenever this kind of ambiguities are there, one has to take a call and have to do it accordingly. At the same point of time, no doubt about it, as Randhir rightly mentioned, SEBI has to come with again a disclosure. I mean, okay, for which again we have to use our good offices wherever we have the opportunity to sensitize SEBI in this particular regard. Let us do that. Okay. Yeah.
Yeah. Okay.
SEBI has issued a circular on May 31st, 2021 and has prescribed a format for the corporate governance report. It is divided into 4 annexures. Annexure 1 is to be submitted on quarterly basis. Annexure 2 at the end of the financial year. Annexure 3rd at the end of 6 months from the close of financial year, and Annexure 4 on half-yearly basis. So Annexure 1 is being divided into parts. Part 1 is about the composition of board of directors, where the details about the every director is mentioned here, like den, category in which he is appointed, date of birth, his disqualification status, whether special resolution has been passed, if the regulation 17(1) of SEBI LODR is being attracted, that is where he has attained the age of 75 years and above. So a special resolution is required. So for in that case, SR is passed or not for his appointment. And the other details like the number of directorship in the listed entities, number of independent directorship in other listed entities, including this listed entity also, number of membership and chairpersonship held by the directors. So here in first part, we have to mention each and every detail about every director of the listed entity. Second part of Annexure 1 is about the composition of committees. Here details about the committees are mentioned here. The name of the committees are there. Who all are the members of the committees? It is mentioned. It has to be mentioned here. And the date of appointment of the members and date of cessation is also to be mentioned here in the second part of corporate governance report. Third part is about the meeting of the board of directors. In this, we have to report about the meetings that are held in the quarter, number of the directors that were present in the meeting, and the independent directors were present in the meeting. And we also have to state the compliance, whether the quorum was met or not in the third part. Similarly, the fourth part deals with the committee meetings. As board meetings, we have to mention each and every detail. In the fourth part, we have to mention about the meetings of the committees that were held during the quarter and the number of members present and the independent directors present in the said meeting. Fifth part is about the related party transactions. Before we state the compliance about the related party transactions or we fill the fifth part of corporate governance report, one must ensure that they have gone through the regulation 23 of SEBI LODR and other regulations of the LODR and Companies Act as well, to state the compliance whether they have fully complied with the related party transactions and the provisions as well, because it asked whether the prior approval of audit committee has been obtained or not. The shareholders approval has been obtained for the material related party transactions, and the details of related party entered into pursuant to the omnibus approval has been reviewed by the audit committee or not. So while we fill the fifth part of our Annexure 1 related party transactions, one must go through the other regulations, specifically regulation 23, to state that the company has fulfilled all the compliances, have done all the compliances or not.
On related party transaction, there are somebody has put a question. We have to find the related party transaction and the quarterly results in SBRL and all the stock exchanges separately on the same date. That is what he is asking. Then there's another question is there. What is the time limit within which and the PDF and related party transaction, the results should be filed with the stock exchanges? That is the next question. The date of the appointment of the CG report is the actual date of the appointment or when the director is regularized at the general meeting. Is RPT mentioned in the part 5 of the regulation 27 is during the quarter or the whole year?
I think the first question, which was on PDF versus XBRL. So XBRL filing is not separately mandated. Ideal condition is that you file simultaneously on the same day and make it available at the same time with the exchanges. Although there are so many requirements related to XBRL, for example, there is requirement of PRSR, which is a very voluminous document. And many times when you try to file XBRL, the format is also changing. So once you have filled that may go with NSE, it may not go with BSE, it may go with BSE, it may not go with NSE. So many times those technicalities are also involved into XBRL filing. But I think both the exchanges are aware of this, and they help you, support you when you are facing any difficulty. I have not come across any situation which I would say was a problem in XBRL filing.
The question you want to take at now or at the end of the session?
Yeah, we can take at the end of the session. I think.
Yeah, that will be better. And somebody is also asking that what are the consequences? His question is relevant that what are the consequences in case independent director vacancy is not filled after 3 months post his resignation?
I think if number of independent director, that condition is met, then there is no repercussion. If number of independent director is not met, then of course there is consequences, and SEBI provision provides consequences for different provisions, and there is consolidated provision also. So one has to see those aspects and then see what may be coming up. And I would say most of these are corporate governance requirement. So SEBI notices coming itself is very big in terms of the compliance requirement and how investor and everyone else see it. So it is not like some small penalty which is there in the Act, Companies Act or somewhere else. But once you are listed and it's a SEBI regulation on corporate governance, they all work currently at least at a very severe level, not because there is penalty, but because it's a governance concern that the company is facing, and the investors and everyone is looking at you from that lens. And I won't see that companies would take it lightly, that any governance issue is open.
So it will be viewed very seriously, forget about compliance, but as the competent part on the part of company towards the compliance and governance, rather than penalty as a main area of.
Right.
Thanks for you.
In fact, in the recent past, SEBI has actually come out on the fine and penalties more or less in the line with the Companies Act. That means, on the continuing offences penalty, what is being done in the Companies Act. So similarly, they are also putting the framework on that. But anyway, I have not seen as such any case law, I have not come across. But as Randhir said, it's a governance issue. Days to come, we will definitely see the regulator will definitely take it very seriously. But on the other hand, there have been certain cases where the independent director position was not filled up within the time limit under the Companies Act. There are various adjudication officers under the MCA, under the Companies Act, not under the SEBI. They have actually passed the adjudication order, heavily penalizing the company and the other board people. That is it.
Yeah, thank you.
Just I want to add one more thing also is that sometimes it may so happen whenever the non-compliances are taking place, SEBI may not act immediately. But certainly what happens is that any kind of non-compliances are going to be there on record. The reason being the secretarial order has to qualify that, whether it is under secretarial audit or suppose under secretarial compliance report. So that is going to be there definitely in the public domain. So the proxy advisory firms are taking a note of that. The stakeholders are taking a note of that. And similarly, in future, whenever you require SEBI clearances, that point of time, all these kind of non-compliances will come to your, and they become a headache for you. So, and second thing is corporate governance means what? Corporate governance means it is expecting impeccable compliances from you. Entire chapter 4 talks about nothing but corporate governance only. And there also, if we say that, suppose if I non-comply, what kind of penal provisions are there? Actually, the thought should not come. Number two, as far as this compliance governance report, which is to be submitted to SEBI on quarterly basis, half-yearly basis, and yearly basis, if I am not wrong, this was introduced in 2018. Prior to that, it was a very, what's called as a bland report. We used to do it. There is nothing there in that, and except the tick box kind of exercise. If you see this report, it talks about board composition, committee composition, how many board meetings have taken place, who have attended, who have not attended, quorum is there or not there. Similarly, in case of related party transactions, it is asking you, have you done this? Have you done this? Have you done this? It is nothing but checks and balances. By any chance, any kind of mistake or non-compliance takes place, while you are furnishing this report, it will automatically come to your knowledge. So this corporate governance report, if one take it seriously, and in fact, at one point of time when this was introduced, we thought that we will prepare on monthly basis, so that instead of after 3 months you come to know about any non-compliance, you will come to know on monthly basis only. So as a company secretary, when you are heading the group, there may be n number of companies might be there. So though they are not listed companies as such, though they don't need to file with the what's called the stock exchanges, when you have material subsidiaries or major subsidiaries, we can also introduce these kind of formats there so that the company secretary who is heading the group can have the checks and balances in place and he can have a kind of comfort. We have introduced this particular thing for our major subsidiaries when I was working with Reliance. Yeah, go ahead.
One more thing, Sudhakar, I just wanted to know for my own interest. The regulator can go how many years back for the non-compliances, initiating action?
I don't see
there
any.
is no time limitation. I think if I am not wrong, there is no limitation act applies as far as your non-compliance things are concerned.
If you see the Sahara case, I think 2 days back only Chairperson SEBI has given a statement that the legal issues is related to the company, which is a juridical person, and the natural person will come and go, right? The investigation will go on. So with that lens, I would say that once those things are committed, probably it will take its own recourse, and there is no such limit, at least in SEBI.
But certainly one thing is there. That the directors who were not there at that point of time when the non-compliance has taken place, they will not be held responsible for sure.
Yeah, that's the very clearly provided in both.
Yes.
Why I asked this question is, I think one of the ROC of Rajasthan, he actually passed the adjudication order recently in the year 2023 for the offences starting from 2015-16 onwards. That means going back almost about 2015-16 to 2023, maybe 8-9 years back. That is why I asked this question.
No, Bala, if I'm not wrong, a couple of years, I think 1.5 years before a question was raised, whether the ROC can take care, raise issues or take up the matter, which was non-compliance under the Companies Act 1956. Because now the Companies Act 1956 is no more in existence. The answer to that is very much, and ROC is very much within his powers to ensure that any kind of non-compliance is taken under the erstwhile act also. Because there is no sunset clause as far as that is concerned.
Yeah, that is true. In fact, there have been offences of 1956 Act which they are taking up and they are actually penalizing it.
Yes.
But the only thing is, now what happens is in certain things, the maintenance of the records of the company, there is a, guidelines or things is there that to maintain the records only for the period of 8 years.
8 years.
That is the question. So if they go back to 15 years back, what the companies do? That was the thing which came into my mind.
See, there are certain records 8 years, there are certain records for 16 years, and there are certain records in perpetuity. Okay. Yeah. So wherever that 8 years period is over, maybe you may be able to take an excuse. Look, we cannot substantiate our claims and all because that we have destroyed the records. But one thing, please remember, there is a proper procedure is there for destruction of records. If you are not compliant with that and you are simply saying that I have destroyed the records and all, it may not be accepted also. So anyway, these are all going to be some legal repercussions will be there. One need to argue based on the situation and circumstances.
Yeah, that is right. That's right. Yeah.
Yeah.
Go ahead, Neerja.
Of cybersecurity incidents, as discussed earlier also, here we have to put the details about the event it has happened. In this table, we also have to specify the date of the event and the brief details about the event that has happened, like breach of breach or loss of data is there. So we have to give the status about this also in our corporate governance report.
Just 1 minute, 1 minute. Neerja, please go back. Randhir, one thing is coming to my mind, when this particular column is to be filled in, whether as per regulation 27(2), blah, 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 has been any cyber security incidents or breaches. Can it be said like this, there are very minor, negligible cyber-related, security-related issues are there, okay, which have been taken care of in the normal course of, in the normal course. Can it be mentioned like that instead of leaving it blank altogether?
Yeah, there can be different permutation combinations of
Yeah.
what you can report. And if you report brief details of the event is also there, right? So what kind of incident has happened? I think a robust process around it is required. Internally in the company, the IT team, the security team, the compliance team, they need to have a discussion that this is the reporting requirement, what process we have to follow on a monthly basis. What you said for CZ, that works better, so that you are proactively ready what is happening and what exactly you are going to report. For those quarters where you don't have any such incident, I think they are easy one. But when the incident is there, that is the time when you have to be more, I would say, in the discussion and explore what happened, what was the corrective measures taken, what was the impact on the company. So more detail has to be given in that case.
Yeah, Neerja.
The second annexure is about the website disclosure. It has to be submitted at the end of the financial year. The listed entities are required to provide the information on the website. They have to place some information on the website of the company. So this annexure deals whether the company has compliance with this or not. Specific regulation, that is regulation 46 of SEBI LODR, mentions that every listed entity shall maintain a functional website, and it also specifies the list of disclosures to be placed on the website. The compliance of the same has to be disclosed in this report. And in case if there is any non-compliance, the reason of non-compliance also has to be mentioned in the report. So this was annexure 2 of corporate governance report. Moving to our third annexure, annexure third is to be submitted at the end of 6 months from the close of the financial year. This annexure deals with the compliance status of disclosure on website of the copy of annual report, presence of chairperson of audit committee, nomination remuneration committee, and stakeholder committee at the AGM of the company, disclosure of secretarial audit report of the listed entity and the material subsidiaries in the annual report, submission of annual secretarial compliance report, and compliance regarding disclosure of corporate governance report in its annual report. So here we have to state the compliances, whether the company has compliance with these regulations or not. Annexure 4, it is to be submitted on half-yearly basis. This annexure deals with the disclosure of loans, guarantee, comfort letters, and securities that are given by a listed entity to any promoter or promoter group or directors or KMP or any other entity that is controlled by them. So here the details about the loan or guarantee that is given by the listed entity, all the details like amount outstanding, aggregate amount given, we have to disclose in this annexure. Further, this report has to be signed either by the compliance officer or the chief executive officer of the listed entity. And as I have said earlier, once it is filled, it is validated. Once it is successfully validated, an XML is generated, and the XML is to be submitted to the BSE and NSE stock exchange if the listed entity is listed on both the stock exchange. So this is how corporate governance report is being submitted to the stock exchange. So this was the obligation, this was the regulation 26, 26A and 27, obligations with respect to promoters, directors, KMP, and all the details about the corporate governance report that we have to submit to the stock exchange. Thank you so much.
I think then we'll go through the questions which are there actually. Is it required to have the NRC meeting for the appointment of the senior management personnel? Is it actually not possible in a big and mid-cap companies as well as... 1 minute. It is required to have an NRC meeting for the appointment of the senior management personnel. Question number 1. Is it required? It is not possible for the big and mid-cap companies as all the senior personnel 1 level below MD, WDD is covered.
Maybe I would respond to this. Senior management people are not unknown lot of people, right? They are identified, they are known people, and there has to be clear process in the organization that these are the senior management. Board has to align with it. And then you should have a process which is taking care of the compliances, whether it is succession planning, whether it is disclosure about their appointment, resignation. There are so many other provisions which gets attached to it. Even if we see inside the company, of course, the company has to deal with senior management and take care of the NRC expectation with respect to senior management and how they are moving, how is their compensation structured. So I don't see that there is any challenge in having a process where you first define the senior management and then you have a process to give you a better comfort on compliance. There may be a situation that senior management resigns on a particular date, and that information, how fast travels to you as company secretary, is something that one has to work on. And how the wiring inside the organization is being done, that will depend on how quickly you are informed and you are in control of the compliance.
Yes, another question has come, but I think this question is
not relevant. Don't take it.
Not at all relevant at all.
I already told her to raise it separately. Go to next.
Okay. MD of the listed company can invest the new and the existing startup of individual basis or pro family member. Is this transaction is covered under Regulation 26 or not?
I think Regulation 26 is very clear that securities of the company is the key, right? So if the compensation or the profit, which is part of the agreement, is coming from the securities of the company, right? So if say you are having shares of X Limited and you are agreeing for some compensation or profit mechanism out of those X Limited shares, then only this is applicable. Any other support that MD is going to give to the subsidiary or new company or family business, that may not be attracted. Depending on the situation, it has to be evaluated. Sudhakar, you want to add something?
Yeah, I agree with you. I don't have much to add further on that.
Consequences of the not filling the independent director, that we already discussed.
Next.
Policies which are also required to maintain with a listed company in respect of the today's topic.
Sorry,
I'm also not getting what is it.
Yeah.
Yeah, I see that. You can say that you have to, that NRC has to have a remuneration policy if you want to have that thing, Because, say, for example, there should be a policy, according to me, for selection of, they have to establish the criteria of independent directors. Similarly, they have to also have a policy for selection and the recruitment of the KMPs or senior management people. So NRC, because we are discussing with to some extent NRC related also, those policies may come up here. So remuneration policy is one of the major things which I can talk about.
Compensation includes what? Please guide with the example.
Maybe compensation has a normal connotation, right? And it is very, very wide what can be considered as compensation. So I would not like to limit it depending on situation, what you get in return of having agreement has some consideration, right? So any consideration can be compensation. in this provision.
The date of the appointment, the corporate governance report is actual date of the appointment, or when the director is actually regularized at the general meeting.
It's actual date of appointment. Date of appointment is only one, which is
It will be right from the day on actually. Yeah. Is RBT mentioned in a part 5 of the regulation 27 is during the quarter or for the whole year?
For CZ, it is during the quarter what is required to report it, because every quarter you are filing this report and it pertains to that quarter, whatever information is being filed.
If the listed company have the executive director finance, is the company required to appoint?
Just Bala, 1 minute. I want to add only one thing here. When you are reporting in the quarterly basis in the corporate governance report, your RPT transactions, and again, when you are reporting RPT transactions under 23(9), please ensure the compatibility is there between these two reportings. At the same point of time, at the end of the year, what you are going to furnish in your annual report, RPT transactions, they should not be in contradiction with each other. So one need to be very careful while reporting this quarterly, half-yearly, or yearly transactions. And even the company secretaries who are going to audit, secretarial audit or compliance certificate, they have to focus upon this particular issue also. They have to have the cross-check wherever it is required. Otherwise, tomorrow, if there is a kind of what's called as the compatibility issues are there, even the alter negligence also may come up.
Yeah. RPT is an area where not only accuracy, but quality of disclosure is also relevant now, because you are making multiple disclosure, and first, whether you are reporting everything, reporting correctly, both are very relevant.
If a listed company have the executive director finance, is the company required to appoint CFO?
One has to designate him as CFO.
Yeah, the executive director will be actually a CFO, but they'll have to designate him as a CFO. Yeah. Can you please take it up?
That resolution under 203 should be passed.
Yeah. Can you please guide me on the procedure of the destruction of documents?
I think document retention policy has to be framed. That's a requirement anyway, and that contains how the when it is the document has served the purpose, or when it completes the number of years for which it is required to be maintained, how it should be destructed, right? So the process has to be followed. It's not one-liner, or it's not something that can be given as a tablet. It is I would say it's a very big exercise. I would say it takes 2-3 months when you actually.
As a good corporate governance, NRC may consider and review such succession plan of the senior management team when an annual planning and budgeting proposals are being considered. I think this is the view expressed. I think that is all. I think so. There is nothing else is left out. I have already taken up all the questions. Yeah.
There is one question added just now. If we are appointing below 1 level official, is it required to take approval of NRC and intimation to be given to stock exchange?
See, that below 1 level official means what? I presume that it is below 1 level below the board. So it comes under the definition of senior management. We have already answered that question.
Yeah, that is right. Because 1 level below means it is a senior management. That is what the definition goes.
Okay.
Yeah.
I think we have covered all the question, answer, and chat box.
Yeah, that is right.
Yeah.
Neerja, before we close, I would like to express my sincere appreciation to you, because nicely presented, very briefly put up everything together and explained very nicely. You have done a wonderful job. I must really acknowledge, receipt, and appreciate. Dipti, your word final.
Yeah. Thanks, Mr. Randhir, for your time, sharing your experience, knowledge. And thanks a lot and we will like to invite you in future also. Thanks. Thanks, Sudhakar. Thanks, Mr. Bala. Thanks, Neerja. Thanks everyone for your time and support and contribution. Thank you.
Thank you. God bless you all.
Thank you.
Thanks a lot to everyone. Have a good weekend. We meet yet again next week.